Hi, and welcome to another episode of Hot Takes with me, the Silver Fox. And as we know, or as our regular viewers know at the very least, Roger Livermore works very close with the channel. He is a man of great knowledge and integrity, a man who's worked at the very highest levels, an ex-Crown prosecutor indeed. And we have, over the past sort of few months, explored some of the big problems legally with Scotland's entire government, and indeed the fact that its entire justice system seems to operate outside the law. This can cause major problems going forward. We've talked about what he's sent to Humza Yousaf, what he's sent to Shona Robinson, what he's sent to Dorothy Bain. All very important people. He sent emails everywhere. We did, on the recent one, we looked at the Joe Farrell email and how he explained to Joe Farrell in great extensive detail why technically Police Scotland doesn't even exist and why she is technically not the Chief Constable and that she's operating outside of the law. And now we've got the latest one, which is an email he sent to Prime Minister Rishi Sunak, and we're going to take a look and go through this to see exactly what he's saying upon this. It is a fascinating look. He does not present opinions. He does not present opinions. He presents flat, cold fact. There is no getting away from what he's saying is actually the truth. So let's take a look at that truth. Let's have a look at what he's saying to the Prime Minister and go through another email from Roger. Here goes. Now again, I've just had to shift this around a bit because it is an email and I don't want to reveal Roger's personal email address. So I've had to jiggle it about, but we're there. So to the Prime Minister, Right Honourable Rishi Sunak MP, Dear Prime Minister. Number 1, summary. Unconstitutionally and unlawfully, the Scotland Act 1998 abolished the rule of law in Scotland. It also unconstitutionally removed the separation of the powers. This made it impossible for Scotland to have a lawful, constitutional or functioning justice system. This should be guaranteed to be the biggest failure in Scottish and UK legal history. Inter alia, the Act unlawfully transferred what must be independent judicial processes, criminal prosecutions, the investigation of deaths, private prosecutions, over to the control of the Scottish Government. The Act produced a political and unlawfully party-controlled justice system, an unlawfully government-controlled police force, and an unlawful government-dependent judiciary. He's not mucking about, is he? With the Scottish Government as the prosecutor, the Act created a government outside of the constraints of the law, sections 44 and 48, and the government cannot enforce the law against itself or prosecute itself. The rule of law vanished in Scotland on the 1st of July 1999. Substance. The Scotland Act 1998 remarkably abolished the rule of law in Scotland. In the totality, this has extremely serious consequences for Scotland, but also places the UK in breach and with it further international implications. And there's a link to a reason why. It says the first and main requirement of the rule of law is that no one can be outside of the law, and especially not a government. The Scotland Act 1998 made the Scottish Government the prosecutor and the investigator of deaths, and therefore unconstrained by or answerable to the law. Section 44, the Scottish Government. 1. There shall be a Scottish Government whose members shall be A. the First Minister, B. such ministers as the First Minister may appoint under Section 47, and C. the Lord Advocate and the Solicitor General for Scotland. Point C, of course, is the bone of contention, because at that point, under point C, you do not have the division of powers, you have justice as part of the government. Section 48, the Scottish Law Officers. Part 5. Any decision of the Lord Advocate in his capacity as head of the system of criminal prosecution and investigation of the deaths in Scotland shall continue to be taken by him independently of any other person. Section 48.5 confirms that the Scottish Government ministers, the law officers, run the judicial processes of prosecutions and deaths. They are always the government. The second half point to the constant offences by the law officers who act on advice and information from the Scottish Government's ministerial-led department, the COPFS, which is even staffed by government officers. The role being both the head of prosecution and the head of investigation of deaths in any case contains a conflict of interests and must be separate. These two sections of the 1998 Act removed the separation of the powers and abolished the rule of law. As the prosecutor, the government cannot prosecute itself. This is an extreme case of nemo judex in causa sui, and governments are prohibited from being the prosecutor by a whole raft of constitutional and human right law. The European Convention on Human Rights, the Human Rights Act, the Constitutional Reform Act 2005, and in Scotland, additionally, the Judiciary and Courts Scotland Act 2008, and by common law. And yet, in Scotland, the government is the prosecutor. It's in breach of all those laws. Therefore, of course, the Scottish Government is in breach of the law, and the Scottish Government should not exist under that law because it is illegal. 3. Scottish Government unaccountable to the law. The Scottish Government, being the prosecutor, is unlawfully accountable to the law. This also applies to its direct ministerial reports, NHS Scotland, Scottish Prison Service, and other associated bodies. One part of the Scottish Government cannot prosecute another part of itself. The governance of the government minister, the Lord Advocate, and their COPFS, and all these bodies is the same. They lie with the Scottish First Minister. It is entirely the SNP government. The Scottish First Minister is unlawfully also outside the law. The government would both be prosecutor and prosecuted. It would be the government's prosecutor, Lord Advocate Bain, versus the SNP government's legal representative, Lord Advocate Bain. Question: how can the Scottish Government and its ministers be prosecuted? Answer: currently, unlawfully, they cannot be. So the SNP government and its bodies ignore the law with impunity. Major cases are on patient safety and related to 2,000 deaths a year. They and the Health and Safety Executive of Scotland also ignored the UK-wide law on dangerous pathogens. That resulted in the government's approach to infection control via the Scottish-dominated Four Nations IPC cell, adopting Scotland's homicidal National Infection Prevention Control Manual. This being catastrophically imposed across all of the UK. That can be guaranteed to be responsible for many thousands of COVID-19 deaths across the whole of the UK. 4. Cause. The Scotland Act 1998 has a number of major errors. The removal of the rule of law and the separation of the powers are fatal schoolboy errors. The Unlawful Act, the bill, was created by the Scotland Office and presumably by its law officers, the then Advocate and Solicitor General. They decided that they wanted to be ministers as well as prosecutors. The bill was rushed through Westminster without requisite scrutiny, and when creating a new parliament and system of government, and Hansard shows warnings of creating a Titanic, but that these were ignored. So it was raised in Parliament. These issues were raised and they were decided not to be acted on. So somebody ultimately has to have made that decision. That person must face the consequences. The current Deputy Speaker, Dame Eleanor Lang, DBE MP, was Shadow Secretary of State for Scotland at this time. She and colleagues in the House of Lords voiced concerns and may wish to comment. But I bet they don't. I bet they are running for cover because they know what they've created. It's an absolute monster. 5. Consequences. Westminster exceeded its powers by removing the rule of law. It gave control of what must be independent judicial processes such as prosecutions and the investigation of deaths over to a government of the day. It removed the separation of the powers. It produced unlawful judicial processes, an unlawful government-dependent judiciary. The government decides what cases the judge get or do not get, also known as enemies get prosecuted, friends go free. And an unlawful government-controlled system of policing, see below. We'll come to that shortly. 6. The Scottish legal profession. The Scottish legal profession has known long of the fatal errors in the Scotland Act of 1998. They have known right from the start in 1999 that it was unlawful, unconstitutional, dysfunctional and corrupt for the Scottish Government to control the justice system. The Senior Justice of the Court of Session made a representation to the Calmer Commission, 10 years of devolution, but nothing happened. The judges and the justice system continued on their unlawful way until now. Nothing has happened on Scotland's unlawful justice system, and so we have an extreme example of boiled frog syndrome. The Lord Advocate and Solicitor Generals also knew that the justice system was flawed. ASAP NHS pointed out the obvious to Lord Advocates Mulholland, Wolfe and Bain. All Scottish ministers and First Ministers would have known that it was completely wrong and unlawful for the government to control the justice system. If they did not, then they should never have even been MSPs, let alone ministers, I suppose. 7. Lost democracy. Democracy requires the rule of law and the separation of the powers. For example, by the Copenhagen criteria and EU rules. Without the rule of law or the separation of the powers, Scotland is not a democracy. So Scotland has not been a democracy since devolution day, the 1st of July 1999. Scotland is 1/12 of the population of the UK. However, it has put all of the UK in breach of the rule of law and of international law. For example, the European Convention on Human Rights, Articles 1, 2 and 6. 8. The Chief Justices. The Lord President of the Court of Session is the head of Scotland's judiciary. The position is highly problematic. Judicial independence is supposed to be guaranteed in law with a legal duty on Scottish ministers, the Lord Advocate and the members of the Scottish Parliament to uphold judicial independence and barring them from influencing judges through any form of special access. This is not true. The Lord Advocate is the SNP government minister for prosecutions and the investigation of deaths. This in a government headed by the SNP Scottish First Minister. It is the SNP government under the SFM that says what cases the judiciary get and what they do not get. The SNP decides who gets prosecuted and who not. The SNP decide if any deaths are investigated. There is no HM coroner or any equivalent. It is not the government-run 30-a-year fatal accident inquiries. The government, via their COPFS and the Lord Advocate, control most of the evidence in judges' courts. That is, the Scottish judiciary are direct agents of the Scottish government. It can never be legally required independent judiciary. The Scottish justice system is rather obviously neither lawful nor constitutional. It begs the question of what the judiciary has been doing. They have allowed the SNP government to constantly interfere with the judiciary. This would appear to make them complicit in criminal offences by the Scottish Government, Scottish First Ministers, Lord Advocates, Solicitors General and General Civil Servants in the ministerial-led government department of COPFS. Has there been a worse failure of judiciary in Scottish and UK legal history? How can judges countenance the absence of the rule of law in Scotland? It challenges what the 5 Chief Justices since devolution have been thinking. The issue now is with Lord Carloway. Anyone from outside of Scotland with even a little knowledge of the law, let alone a law degree, should find the Scottish situation beyond belief. There has clearly been no external independent due diligence check of what the Scottish judiciary has been up to. What he's saying in there is that maybe there's a case that needs to be taken. It'll be up to Humza Yousaf to decide whether they will prosecute or not. Not the courts. Up to Humza. And he can decide what evidence for both sides may be presented. So even if it goes to an independent jury, the jury will not necessarily see all the evidence. They'll see the evidence that Humza Yousaf has decided that they'll see. Does that not strike you as being somehow wrong? Anyway, the Scottish judiciary is very small. It is in effect a monoculture, operating in isolation, accountable to no one. ASAP NHS covers it almost total failure elsewhere. It is proving difficult to find anything at all that could be lawful. All the judiciary are dictated to. This is by what the Scottish Government gives it and what it does not. The Scottish judiciary constantly acts with unlawful bias. They do not uphold the law of the land, particularly not on patient safety or dangerous pathogens, as in the pandemic. This failure is responsible for tens of thousands of deaths in Scotland. The Scottish judiciary stand in opposition to the rule of law and the law on human rights. Their oath of office might as well not exist under the Promissory Oaths Act of 1868. There has not been a due diligence test of whether the Scottish judiciary upholds the law, delivers justice, and does so efficiently. It patently does not. It fails all the tests of being a lawful, constitutional, and functioning judiciary. 9. The rule of law ranking. The international standard for the rule of law is given by the World Justice Project. Currently, the UK is ranked at 18th. Scotland fails the rule of law tests and would be vying for bottom position in the European League. 10. Bingham Centre for the Rule of Law. ASAP NHS have advised the Bingham Centre of these matters, and it should be shocking that the very obvious failures of the Scottish justice system have not been addressed. The Bingham Centre could be best placed to identify the means to solve the Scottish situation. The current situation absolutely cannot continue. The Scottish justice system could collapse at any time and by tens of different ways. It requires the UK government, acting on the Reserved Scotland Act 1998 and constitutional and human rights responsibilities, to mount a disaster recovery operation on the Scottish justice system. Without it, the UK will continue to be in breach of major international law. ASAP NHS will be adding to our previous reporting on Scotland's unlawful justice system. Yours sincerely, Roger Livermore. And these are the people he copied this into: Dame Eleanor Lang, Penny Mordaunt, Keir Starmer, Ed Davey, Murray Hunt from the Bingham Centre, Professor Jeff King, Research Director, Bingham Centre, Right Honourable Lord Carlaway, Lord President of the Court of Session, Right Honourable Alistair Jack, Douglas Ross, Anna Sarwar, Alice Cole Hamilton, Lady Peyton, Scottish Law Commissioner, Dorothy Bain, we all know who she is, Joe Farrell, Chief Constable, Sarah Olbon, Health and Safety Executive, and Stephen Parkinson, KC, Director of Public Prosecutions and the Crown Prosecution Service. So he said this to all the important people, and it is a wonderful piece that shows you how Scotland does not have a legal judicial system and has not had since the 1st of July 1999. And you know what's truly frightening? It means every single prisoner prosecuted since then has been prosecuted illegally and may well be entitled to massive compensation. Coming up. Now, while Roger only provides facts, points of law, things that are important like that, he does not provide an opinion, but I will. And I'll give you one very, very quick opinion that I'm going to have. I don't think anything will happen with this, and there's a very good reason. Because for them to address this issue would open up such a massive can of worms. It would utterly devastate everything that's happened for the last 25 years. Nothing that's happened would be legal. potentially, if the if the Scottish Government wasn't legal, then any actions taken by any member of that Parliament would have been taken without the provision of the protection of government. And therefore, they would all be open to prosecution for everything that's happened. And I don't think anyone wants to deal with this. That's why I think nothing will happen to this. I think it's wrong. I think it's something we all need to fight. We all need to demand action. We all need to find someone who's got the balls to take it on. But I don't think it's Rishi. And I don't think it's Keir Starmer. He's about as complicit as all the others. I hope that's proved interesting. Thank you very much for watching. We wish Roger the best of luck, and we wait until he comes up with the next one. The man works tirelessly for us all. Thank you, good people, and goodbye.